Welcome, everyone. Good evening. Thank you for attending this information session on carbon dioxide pipelines issues for landowners and concerned citizens in Illinois. My name is Joyce Blumenschein. I'm a volunteer with the Coalition to Stop CO2 Pipelines. We are a grassroots initiated and led organization. Tonight's program is our first, so bear with us. We will be holding more programs in the future on specific topics. Our coalition was formed by concerned individuals and downstate property owners after a Navigator letter was received by property owners in mid-December of last year. The coalition is going to have a variety of speakers tonight, which I'll introduce shortly. Right now, I just want to kind of give us a grounding for those who might not be aware of the Navigator issue. Please bear with me while I share my screen, and I'll show you a few slides. Navigator Ventures LLC, large-scale liquefied CO2 pipeline, is going to be 1,300 miles of CO2 pipeline across parts or all, in the case of Iowa, of states in central Midwest. And it will affect Illinois by coming in from the west in Hancock County. 13 counties in Illinois will be affected, and there's 280 miles currently planned. So from that background, we know that Navigator is just one of the companies coming to Illinois. This is a webinar, so I do want to mention it might be a little different for some of us. You won't see yourself. We are going to feature our speakers with a highlight. Everyone can post questions in the Q&A. That's a tab at the bottom of your screen. Type in your questions. Our volunteers will read those off after the speakers in order to save time. So our order tonight will include keynote speakers, and then we'll hear from Pam Richard, who's one of our team members. Our first speaker is going to be Jessica Wiskus. She is an Iowa farmland owner who loves her land. The CO2 pipelines expansion hit Iowa before Illinois. Jessica will tell us why this all matters so much and what are her concerns for farmland impacts. Our second speaker is attorney and pipeline issues expert Paul Blackburn. Paul began working on crude oil pipeline issues in 2008. He has worked extensively on CO2 pipelines, renewable energy policy. He's authored a variety of analysis and safety reports. Our final speaker will be Illinois attorney John Albers. John's work has focused on energy and utility matters, including a variety of hearings and proceedings with pipelines in our state. He will explain the CO2 pipeline process that happens with the Illinois Commerce Commission. This is key for pipeline approvals, and all of us in Illinois need to be aware of the process because Illinois citizens can participate. So thank you again for attending tonight. It is now my pleasure to turn this over to Jessica Wiskus.
Thanks so much, Joyce, and thank you to everyone who's joining us tonight. A week or so before Thanksgiving, I received a certified letter from Navigator notifying me that my property was in the pipeline corridor. Well, I have to admit that at the time, I didn't really know much about carbon pipelines, how they were different from other pipelines. But I started to do some research, and what I learned sent me knocking on my neighbors' doors. Of course, the map that Navigator gave me wasn't very good, but since I'm the daughter of a sixth-generation Iowa farmer, it didn't take too long to figure out whose fields and farmhouses would be affected. After talking with my neighbors, I decided to organize a local meeting about the pipeline. And at that first meeting, over 100 people attended. Well, I live in a rural community where trust, integrity, and honesty are all very high. And so my neighbors and I have stood together against this pipeline ever since that meeting. We've distributed yard signs, we've cheered each other on at public meetings, we've sent letters to the Iowa Utilities Board, and we have pledged that we are not going to sign voluntary easements with Navigator. We're going to fight this thing first. And our little group has grown in numbers, joining with a statewide nonprofit organization to help us fight against the abuse of eminent domain. Why are we so opposed to the carbon pipelines? Look, we know very well that individuals sometimes have to make sacrifices for the greater good, We know it because that's how our families have survived here for so many generations. We help each other. We stand for something greater than just ourselves as individuals. But these carbon pipeline projects are not for the greater good. For one thing, carbon pipelines are uniquely dangerous. You will hear more about this in the presentations to come, but I will just say that in Iowa, at least, Navigator's route puts farmhouses, ball fields, churches, historic buildings, Native American burial mounds, and even school districts in the pipeline corridor. I know that maybe we're considered too rural for corporate executives to care about, but we live here, our families live here, and we have built our communities here. Secondly, we're opposed to the use of eminent domain for these carbon pipelines. Eminent domain takes away our land, what we love, and gives over its use to a private company for their profits. And what will this look like? As it turns out, Iowa recently experienced a kind of test case of modern pipeline construction when Dakota Access came through our state in 2016. Photos here, graciously provided by an Iowa farmer who went through it, show evidence of mixing of soils, compaction, draining of water into surrounding fields, damage to the tiling, and more. This farmer was not alone in his heartbreak. Last fall, a report in Iowa Farmer Today about the Dakota Access Pipeline quoted a professor from ISU. He said, "Our findings show extensive soil disturbance from construction activities had adverse effects on soil physical properties, which come from mixing of topsoil and subsoil, as well as soil compaction from heavy machinery." You see, the pipeline company obeyed the letter of the law when they separated out the topsoil from the subsoil, but then they drove over the topsoil while they were building the pipeline, mixing the soils. And they worked the land under extremely wet conditions, compacting the soil. The tiling was never made right, and farmers were left with reduced fertility, problems with erosion, and lowered yields. In this photo, you can see the scar 2 years later. All of this has direct financial consequences for rural families, of course. And that's not to mention the damage that pipeline construction does to ecological systems like restored prairies, wetlands, forest reserves, and conservation lands. If you have acres in CRP, the Federal Conservation Reserve Program, I urge you to contact your FSA officer as soon as possible to learn more about what pipeline construction would mean for your contract. Bringing to bear the power of condemnation through eminent domain would trigger a whole host of consequences for landowners. And that's why my county's Farm Bureau, citing potential infringement on the private property rights of Iowans, submitted an objection to the Iowa Utilities Board against Navigator's proposed pipeline, stating, "Representing Linn County Farm Bureau members, we are requesting the Iowa Utilities Board to deny the use of eminent domain for Navigator LLC at this time." You see, this pipeline deeply offends farm families out here. It's not just about our land, it's about the land that feeds the world, the land that we all care for, the land we steward, the land fertile and rich that we want to pass to the next generation. The soil that we have here is irreplaceable. Mother Nature took 1,000 years to make it, but a pipeline would undo all of that. A farmer's wealth is in the land. Everyone knows that. But what do I mean by land? Soil is a part of what land is about, no doubt. But that isn't all that I mean when I say that a farmer's wealth is in her land. Land, for many of us, means something more than just a line on a balance sheet. Land isn't just a possession. It isn't just dirt. It's about our heritage, and it's about our hope. Land for us is about the abundance of life that is rooted in the earth and that fundamentally is not of our own making. One of my neighbors said to me, "It's not like the land is a part of me, but like, I am a part of the land. And he said it well. That's the gift bestowed on us by the land. It places us face to face with something greater, something true. And so the wealth of the land isn't about what we own. It's about to whom our lives are responsible, to corporate executives, to private investors, to powerful politicians, or to the gift of life that we are called to steward. Private corporations want to take the part of the wealth that is seen on a property deed, but they disregard what the land really means. They disregard the part that is the true gift. It's because of this that we will not sign voluntary easements with these pipeline companies. And look, it takes strength to stand up to powerful corporate and political forces. But that strength doesn't have to come from you or from me alone. I would just ask you, please, after this webinar, please go outside and consider all the strength that Mother Nature has shown you and what you might show for her in return. And know that your neighbors are considering the same thing. Think about joining together as we're doing in Iowa, however you can, standing neighbor to protect the land. Thanks so much for listening to something that is very, very close to my own heart, and I believe close to yours. So I just want to pass this on to Paul Blackburn, who will speak next about carbon pipelines, about their safety risks, and about the rush to build them in the Midwest. Thanks.
Hi, everybody. I'm Paul Blackburn, and I wanted to thank you for being here tonight. And first, I'd like to show a quick video. So let me share my screen. This is a video prepared by a European standard setting and consulting group, and it shows a pipeline rupture that was done intentionally as an experiment to test some of the models for where the CO2 would go. And I wanted to say first, this is an 8-inch pipeline. It only releases the equivalent of about 4,000 meters, or about 3.5 miles of pipe. And the amount of CO2 that comes out of a pipe is generally is set by how big and how large in diameter the pipe is and how many miles of pipe vents. So this is just 8-inch and 4,000 meters. So let me play this.
This video shows a rupture of a buried, dense phase carbon dioxide pipeline. The experiment was conducted in a safe environment of the DNVGL Spain Adam Testing and Research Centre to assess the consequences of such ruptures in terms of mass outflow, crater formation, and dense gas dispersion. The viewer should note that the extent of the visible plume does not necessarily represent the extent of the dense gas plasma.
So let me switch here to my presentation. So again, that's a relatively modest size pipeline and a relatively small amount of CO2 that came out of it. So what I'm going to talk about tonight is some of the technical, regulatory, and development issues. And obviously 15 minutes is not enough to talk this through in any kind of detail. So I will look forward to answering questions as well, but a lot of these issues are quite complex and they're going to take some time, but just want to give you a head start with some of these issues and let's move ahead. So what is supercritical CO2, carbon dioxide? Supercritical CO2 is carbon dioxide. That's under so much pressure. It has characteristics of both a liquid and a gas. It's a hybrid kind of substance.
Paul, excuse me a second, but we don't see your slides. You might have to go out and screen share again.
Okay.
Thank you.
Let me get to that then.
Perfect.
Okay, there we go. So you can see them. All right. So what is supercritical CO2? Well, like I said, it's this hybrid substance. And the reason that it's important for enhanced oil recovery and for carbon sequestration is that, like a gas, it can move through porous substances like porous rock and can be ejected underground. But like a liquid, it can dissolve and mobilize certain kinds of hydrocarbons, such as oil and even plastics. And one of the things that's unique about it is that very small changes in pressure, temperature, or contaminants in the stream flow can result in really dramatic changes in how it behaves. And just as a sense of it, it's also about as heavy as water. So as I said, the reason that they want to ship it as supercritical CO2 is two reasons. First, that it's much denser than a gas and it's more economical to ship it that way. And the second reason is because it needs to be in that state for sequestration, and if it's used for enhanced oil recovery for that reason. And it is the same as transporting oil and natural gas, and it really isn't, because of this hybrid liquid gas nature. The supercritical CO2 just simply behaves differently during operations and ruptures. The high pressure and varying temperature and impurities make it quite difficult to predict how it's going to react in different circumstances. And this unusual properties create a number of safety issues. And unfortunately, almost all the CO2 pipeline safety research appears to be being done in Europe. I mean, the fundamental reason is that oil and petroleum products are liquids, and they stay liquids, and natural gas is a gas and it stays gas. Supercritical CO2 is a funny hybrid, and if it's not controlled carefully, it can switch back and forth between gas, liquid, and a supercritical state, and that can be quite dangerous. Also, supercritical CO2 can be very corrosive. If even microscopic amounts of water are mixed in with the CO2 stream, it can rapidly corrode the high carbon steel pipes through which it will flow. And the companies know that, but the question is, will they be able to keep the water out of it reliably over time? And also, other contaminants can work synergistically. They can be corrosive too, but they can also work synergistically together to accelerate corrosion, and that's not particularly well understood. And then, like I said, because it can dissolve hydrocarbons, it can also dissolve seals, coatings, lubricants, and other non-metallic materials, which might work fine in oil and gas pipelines, but not everything that works in them is going to work in a supercritical CO2 pipeline. So what about the pressure impacts? Well, if there's a rapid drop in pressure, it can significantly damage pipelines. First off, there are what are called running ductile fractures, which don't typically happen in natural gas and never happen in oil pipelines. And we'll talk about that in a second. And small changes in amounts and types of contaminants in the stream can change the way it behaves significantly and have dramatic impacts on safety. And in addition, changes in shipment amounts, for example, during cyclical cycles, market cycles, or seasonal variations in CO2 production, can change the way operations and safety of a pipeline. When a supercritical CO2 pipeline ruptures, the CO2 rushes out, and most of it converts to a gas, but some of it, because of the rupture and the depressurization, forms dry ice, which forms at minus 109 degrees Fahrenheit. That dry ice can have a significant impact on pipeline operations. It can jam up valves. I've looked at all the CO2 ruptures in the last decade, and many of them relate to dry ice formation in a pipe as it's depressurizing. That interferes with its operations. Super cold temperatures can also simply make the steel pipe quite brittle. And it's also possible for the steel to contract quickly enough that it can detach internal and external coatings of the pipe. And there are significant risks of humans to animals once the supercritical CO2 comes out of a pipe. And these include asphyxiation. If there's too little oxygen in the area, it can suffocate people. And it can also intoxicate people. And you can see some of the lists there of typical symptoms of CO2 poisoning. And with high enough levels, it becomes quite dangerous. But even at lower levels, it can cause intoxication. And certainly people are using heavy equipment or outside in the wintertime or driving vehicles or whatever. I mean, intoxication can be quite dangerous as well. And what we really need to do here in part is we'll talk about this more, but is to start determining the danger zone for these pipelines. And again, the danger zone depends on the diameter of the pipeline and how much CO2 would come out. And there are certainly models that can do that. We'll talk about that in a second. Probably the best known CO2 pipeline rupture was a 24-inch pipeline that ruptured in Satartia, Mississippi in February 22nd, 2020. That about 9.5 miles of pipe released 9,532 barrels, the company estimated. 49 people were hospitalized and over 250 evacuated. Satartia is a very small town. That's most everybody was in the town. And the first responders were put at risk. Satartia was almost exactly the center of Satartia is almost exactly 1 mile from the pipeline rupture. And when the first responders got there, they started becoming intoxicated themselves, and even their vehicles had stopped functioning. 3 men who were caught in it, 3 of the citizens there were caught in it in their car stalled because there wasn't enough oxygen in the area for the car to run. So there's one of these ruptures and enough CO2 comes out, it can be quite difficult for first responders and emergency personnel to get in. It can be quite difficult for victims to try to get themselves out because they could be intoxicated and not know what's happening. They are described as walking around like zombies in Satartia, and their vehicles may not work. Here are some symptoms from the USDA. You can see at 4%, 40,000 parts per million, it's considered immediately dangerous to life or health. It's the standard government term. At 5%, you can see that it starts creating confusion and headaches and shortness of breath. And at 8%, there's even more significant impacts. And it's also possible for people to become unconscious and pass away. In Satartia, some people did pass out from the gas. So what's a running ductile fracture? Well, when the CO2 ruptures out of a pipeline, the supercritical CO2 starts turning to a gas. And this gas expands, and the pressure of the expansion can actually rip the pipe open. So, when the CO2 comes out, it starts converting to gas outside of the pipe, but then the conversion starts happening inside the pipe. And as it rips the pipe open, more of the CO2 gets converted inside the pipe further along the pipeline route. And this can just simply unzip a pipeline. And this can be stopped with stronger steel or crack arresters. But the question for stronger steel is how strong, and the question for crack arresters is how closely are they sited. And what the Europeans are finding is the existing engineering models that are used for natural gas and oil pipelines are simply not adequate. Here's a picture of a test rupture that was done in Italy. You can see the right-hand side there are a couple of people on that red circle to give you a sense of scale. That's a 24-inch diameter pipe. It was a 50-meter test rig, and that pipe just ripped open for essentially 50 meters and blew that trench in the ground when it did it. So that's the kind of violence. Even though these pipelines don't explode in the sense of burning, there's still a tremendous amount of pressure and force inside these pipelines that can be released and do a great deal of damage. This on the left-hand side is a picture of the crack arrestor where it stopped. It looks like it's probably fiberglass wrapped around the pipe. It could also be steel. On the right-hand side, it shows what happens if if the steel is just strong enough to stop it. And again, this is relatively complex engineering, and they're doing these tests to try to verify the models. And their conclusion from this test was the models simply aren't good enough to determine how strong these pipes need to be. So what about dispersion modeling? Well, that means that it's a computer model that figures out how far the CO2 is going to go from the rupture to the level where it's dangerous. And citizens, first responders, have a right to know if they're in the danger zone or not. And there are many models that can be used, including sophisticated called computational fluid dynamic models that can take kind of weather and topography and buildings and structures, and to determine how far away people are at risk if there's a rupture in the pipeline near them. But as far as I know, the regulators in the industry have not defined what these danger zones are. We know what they are for natural gas pipelines. There's formulas to do that, and that can be calculated. But for the CO2 pipelines, it hasn't been done. We are contracting with a modeling group right now to do some initial studies of the danger zone of these pipelines, and we're looking forward to sharing those at some point. In terms of regulation, there really is no centralized regulation of these. The federal government regulates pipeline safety, which means pipeline design, construction, operation, and maintenance, and it also regulates certain water crossings. The states generally have the right to regulate route and overall project approval. Not all do, but Illinois does. Emergency planning response is not centrally regulated. The federal government doesn't federalize police and fire department response, emergency response. It's up to the counties and the state to work out the emergency response plans to these pipeline for their crews to respond to a pipeline rupture and for citizens. In some states, there can be county zoning, but that depends on state preemption law. And there's no federal regulation of the commercial aspect of these pipelines. Natural gas and oil pipelines are regulated by the Federal Energy Regulatory Commission. It determines their profit margins. But for CO2 pipelines, there's no commercial regulation. So again, federal pipeline safety law, people tend to overstate what this does and doesn't do. It regulates pipeline operators with regard to the design, construction, operation, and maintenance of pipelines, but not the route. And it doesn't regulate everything that's could conceivably be called safety. It regulates just these specific issues with regard to what the pipeline operator is going to do. So a state can't come in and say, put in stronger steel walls, but it can certainly regulate its own police and fire departments in terms of emergency response. The Pipeline Safety Act, unfortunately, does not require any permits. The way it's set up, it's essentially self-regulating. And because there's no permits required, then there's no public participation requirements under federal law. So there's no way for citizens to participate in anything that the pipeline, any Pipeline Safety Act regulation. And in terms of how the regulatory structure evolved at the federal level, originally the Pipeline Safety Act applied to gas pipelines, and then they added oil pipelines and did a whole set of regulations specifically for oil pipelines. And then a decade or so later, Congress decided that it should cover CO2 pipelines. But rather than doing a specific set of regulations specifically for CO2 pipelines, they decided, because there weren't that many of them, that they would just apply the oil pipeline regulations, lock, stock, and barrel to CO2 pipelines, even though it's a very different substance with different behaviors. So it's kind of tacked on to federal law. And again, federal law, I'm going to emphasize this, does not prohibit local emergency response planning. In fact, if you look at the law, it encourages it. John is going to talk about Illinois state permits and regulations, so I'm not going to get into this, but there is regulation of these pipelines in Illinois. And why is there all of a sudden this rush to build them? I mean, there's 3 different proposals, Summit Navigator and a Wolf pipeline proposal, and there could be more. And the reason is because the federal government has set up a tax credit that's so generous that it's created a gold rush. The tax credit is given to the entity that captures and sequesters the CO2, either as just pure sequestration or enhanced oil recovery. For pure sequestration, the tax credit is $50 per metric ton, and it lasts for 12 years. And it is understood at the time that this law was passed that ethanol plants, to make it profitable, need between $25 and $35 per metric ton. So the federal government's providing a heck of a profit margin for them. And just because the federal government thinks this is a good idea doesn't mean that the technology is ready or the commercial aspects of this have been worked out or that it's really good for the environment. So that's what's going on. And I think one of the most important things about these pipelines is that the scale here is really remarkably different than what's come in the past. The industry talks about how they've had a lot of experience with their 5,000 miles of existing pipelines. A lot of those most of those pipelines, or I think all of them, are from one geologic CO2 source to oil fields for enhanced oil recovery. There are a few that there's one that does sequestration, I believe, but it's short. And so these are relatively simple pipeline systems. The Summit Navigator projects in Iowa are much larger scale and involve many sources and likely many sequestration wells. And this larger scale will likely cause a variety of technical challenges and new safety risks and require new regulations. And it's really important to understand this could just be the first wave of pipelines that come through. These are the Summit Navigator maps. It doesn't go all the way into Illinois, or maybe because it does, but maybe not show all of the Illinois pipe route proposed. But you can see that they're overlapping their territories and they're building pipes all over the place. And just think of the farmers who could be at all those intersections and how many pipes are going to go through their properties. But this could just be the first wave. The tax credits could become increasingly generous, and we could see this doesn't cover all the ethanol facilities in these states. there are many more. And plus there are more fertilizer facilities, cement plants, power plants, other places. And if you start putting all these CO2 sources on the map and then think about where are the pipelines that go between them all, it could become a real mess of spaghetti. And so this could just be the first wave that could be hitting you and your land. This is another map that was done by a study out of Princeton University. And this map shows this very logical approach of trunk lines with feeders going into it, but that's not how this is going to work. The way that's being set up is that the pipeline companies get certain customers, connect them to those particular facilities. So this is looking at this, it's setting 21,000 kilometers, with, 10,000 miles of trunk lines and 40 something thousand miles of spur lines, but that's assuming a rational planned approach. But we're going to be seeing potentially overlapping systems that are redundant and not coordinated at all. So it could be many more miles if the industry gets exactly what it wants looking into the future. So it's really important for folks to understand this is just potentially just the first wave, and whatever you learn now will be very useful in the future. But thank you for your attention, and happy to answer any questions. And I will stop my screen share, and we'll look forward to answering some questions for you. Thank you.
Okay, John, if you're ready, we'll move to you before we do questions.
Oh, forgot to unmute myself. All right. Do you see my screen?
Yes, looks good.
All right. Thank you. It's always tough to follow Paul. I had the pleasure of working with him a couple of years ago, and he is very knowledgeable. I'm going to run through with you how the Illinois Commerce Commission handles pipelines. But first, before I get into that, I should probably describe what the Illinois Commerce Commission is or does. The ICC is an independent executive branch state agency that regulates the electric, natural gas, water, and wastewater public utilities in Illinois, and also common carriers by pipeline, like the kind of pipeline we're talking about here. It still has some authority over telecommunications carriers, but those are largely unregulated, and it does have some additional authority over transportation, like, for example, movers and tow trucks in the Chicago area, and also rail crossings throughout the state. But most people do not know what the Illinois Commerce Commission does, but it really does affect, as you can see, just about every person in the state. Its mission is to balance the interest of consumers with the utility. And to do this, it employs experts in a variety of fields, such as accountants and engineers, attorneys, and financial analysts. And they test the industry's proposals, as well as any proposal by other parties in a case. At least that's how it's supposed to work. ALJs, or I'm sorry, administrative law judges, are attorneys employed by the commission who fill the role of judges. And they hear and consider the arguments and then make recommendations to the 5 commissioners who are appointed by the governor, and they're the ones that make the ultimate final decision in the case. As one of Paul's slides noted, Illinois does have a statute on this topic, and it's the Carbon Dioxide Transportation and Sequestration Act. That was adopted in 2011. There was a particular project in mind when the legislature passed that law. It did not come to fruition. What this statute provides for is the ICC application process for a certificate of authority to construct and operate a pipeline to transport and sequester CO2. Now, the statute itself declares CO2 pipelines to be a public use and service, to be in the public interest, and to be a benefit to the welfare of Illinois. Now, again, at the time, it was geared towards the continued use of Illinois coal, but the language of the statute is applicable to any effort that will reduce CO2 emissions from a particular source or sources. The statute provides that the ICC may grant a certificate if it makes specific written findings. And my wife's always accusing me of lawyering things up, but I do just want to give you an example, or at least provide the list of the things that this statute provides for the commission to consider. One, whether the application is properly filed, whether the applicant is fit, willing, and able, applicant has an agreement with the source of CO2 emissions, and like in the case of the Navigator pipeline, that would be agreements with the ethanol plants that I understand it intends to transport CO2 from. Whether the applicant has filed all of the PHMSA forms, and PHMSA stands for the Pipeline and Hazardous Materials Safety Administration. That is a federal agency. It's part of the U.S. Department of Transportation. They're the ones that implement some of the Pipeline Safety Act provisions that Paul referenced. The statute also specifies that the applicant, should demonstrate that they've applied for all necessary permits from the U.S. Army Corps of Engineers. And the applicant has what in shorthand is called an AIMA with the Illinois Department of Ag. An AIMA stands for Agricultural Impact Mitigation Agreement. State law requires these types of agreements between developers and the Department of Ag for a variety of large projects that are done in Illinois. Pipelines are just one type of project. They also require them for wind farms, solar farms, and basically the AIMA sets forth the terms by which the project company will handle the land, primarily the farmland. It covers a lot of different issues, and appropriately so. Like for example, some of the issues that are covered include the treatment of drain tiles, and the correction of any tiles that are broken. Wet weather work prohibits specifically working when the ground is so wet that it would mix the topsoil with the subsoil. The Department of Ag recognizes that's not a good thing and tries to keep the companies from doing that. In the absence of it, I've seen companies try to talk a farmer into letting them work any time of the year. But basically, they're trying to protect the land as much as the Department of Ag deems reasonably necessary or appropriate. The applicant also must have the necessary financial, managerial, legal, and technical qualifications. In other words, if they know what they're doing and can pay for it. And the statute also requires the pipeline company requires the commission to consider other specific points. And that includes the evidence of the effect on the economy, infrastructure, and public safety, property values. But I'll note that evidence of the effect on property values, but I'll note that the commission will not assess any change in property value. That would be done by a circuit court in a condemnation proceeding if it came to that. Also, evidence from DCEO, that stands for the Department of Commerce and Economic Opportunity. That is the state agency that one of its responsibilities is to try to ensure economic development in the state. So you can see why they would want DCEO to be involved. As a practical matter, DCEO, they're allowed to get involved in a variety of different proceedings and rarely do. And further on in the statute, it says that any party can raise the same type of evidence that are called for in the earlier provisions. For example, it doesn't have to be DCEO that would argue about present evidence on economic development. And then any other state or federal entity can get involved and provide information on security, stability, and reliability of energy. The pipeline company also, under the statute, they have to propose either a preferred route or a preferred route width. And that width can be a corridor up to 200 feet wide. And the rationale in the statute is that once they get going with the project, they may realize that they can't put the pipeline exactly here, but they could put it maybe 100 feet over that way. And that would avoid some obstacle that they weren't aware of or hadn't considered thoroughly in their planning stage. The statute also provides 11-month deadline. That's a pretty tight deadline on particularly large projects like this. The statute also says the construction must be conditioned on the company obtaining all the PHMSA, Corps of Engineers, Department of Ag, and other permits and approvals. So you have to make sure that they have to have all that before they can start construction. Now they can still engage in their planning, easement acquisition efforts, including eminent domain, before they have all the permits, but they have to get all that before they actually put a shovel in the ground. Now, probably the most concerning part about this statute is that if a certificate is granted by the commission, the company automatically receives eminent domain authority to condemn an easement. Now, before condemning an easement, they must use reasonable and good faith efforts to acquire the land interest by negotiation. But again, then it says it's up to the company though to decide when to exercise eminent domain authority, and they can decide to do that if it becomes necessary to avoid unreasonable delay or economic hardship for the project. Now, I've had some ask me, is this constitutional? And I think it's a very good question. I don't know. I'm not an eminent domain expert. I can't tell you that under the Illinois Eminent Domain Act, there are certain projects that the General Assembly provides what's called for as quick take condemnation authority. Those projects, when they're in the statute, are very specific as to what the project is. Whereas in this statute, it's just general and applies statewide. So that could be an issue there. We don't know for sure because the statute's never been challenged in court. It's only been used to the point of it actually having a certificate granted, I believe, just once. And that was the project I alluded to earlier that never came to fruition. So again, there's no case law on any aspect of this statute. But I think the constitutionality of that eminent domain provision is a legitimate, reasonable question to consider. Now, if the pipeline operator does get to the point where they're going to be seeking easements, there's an administrative code part in the Illinois rules. And that's 83 Illinois Administrative Code Part 302. That provides the rules that govern the pipeline company's efforts to acquire an easement. And I mention this because there are two provisions that I think are particularly relevant to landowners here. The first one is in that section 302.30a that I have a quote from. Prior to an owner or operator contacting a landowner to negotiate an easement, it has to file its application at the ICC. I have heard rumors, and I don't know if this is true or not, but I've heard rumors from various sources that Navigator may have already tried to contact landowners to acquire an easement. Now, they can send you an invitation to an open house saying that later we're going to ask you for an easement. That's arguably okay. But if they have specifically contacted a landowner to negotiate an easement, that is not okay. And I would encourage anyone that has been approached to contact the organizers of this webinar. Now, after they file their application, they then can reach out to landowners, but they have to send a certified letter to each landowner at least 2 weeks before they telephone you or knock on your door. Again, that is in the rule and it must be complied with. If it turns out that Navigator or any other pipeline company is not following this rule, it is possible to file a complaint at the ICC pointing this out. The state law provides for certain financial penalties if a company does not comply with commission rules. Now, whether the commission would actually impose a financial penalty is hard to say. The thing to remember, though, is that clearly, it's hard to argue that if they have in fact sent you something, before filing their application, it's hard to deny that happened if you have evidence in your hand. I would like to think the commission would specifically then, direct a company to comply with the rule and cease further contact until it's filed an application. But, one thing to consider here is that, if that happened, it would also, start things off on the wrong step for the company. And I would encourage you to, let the media know about that, advertise it, because it is an important, sign into how the company conducts itself and, does business, whether it's going to follow the most basic rules or not. When you are contacted, or if you are contacted about an easement from the landowner, I would, do not agree to or sign anything. And I listed that twice because it's very important to, to follow that. I have seen plenty of first draft, easements from utilities, and they're, drafted with their interests in mind. They are not looking out for your interest necessarily. Some are better than others, but definitely don't just agree to whatever they offer. And I'm not talking about dollar amounts. I'm talking about how they'll treat the land as well. So the other question that comes up is, I've been contacted by them to just walk on my land and do a survey. There's no need to grant them that access to your property. You don't have to do that. That's solely up to you. They can't make you let you come onto their property for a survey. I would definitely recommend that you have an experienced attorney look at whatever documents that a pipeline company wants you to sign. There are several out there that do have experience with easements, but I would specifically try to find someone who has experience with utility and pipeline easements. I'm going to recommend a colleague of mine. I recently left the law firm of Westervelt, Johnson, Nicole, and Keller just for a different career opportunity. I have nothing against them. I think very highly of them. But my colleague there, Bill Shea, has a ton of experience with these types of easements. So I put his name and contact information there if anyone is interested in just talking to him about an easement they're approached with. Also, as far as easements, one more thought on easements. I mentioned that it's important to consider more than just dollar amounts. I mean, something they can think about with regard to easements. This is not a conclusive list. This is just examples. The agricultural impact mitigation agreement I referenced earlier, including certain provisions you might find in that in your easement would also give you the ability to enforce the terms, or at least those specific provisions, because I would note that the EMA with the Department of Ag is an agreement between the pipeline company and the Department of Ag. It would be the Department of Ag that would enforce it, not you as the landowner. So if you want to have the ability to enforce some of those provisions, it would be, I would consider including them in your own easement agreement with the company. And for that matter, you can go above and beyond the provisions that are in the AMA agreement. If you want a more stricter standard, you can propose that as a counteroffer to the company. I would even consider including repercussions in the easement agreement that would, be against the company if they somehow violated certain terms. What right do you have? What penalty do they have to, comply with? I've seen agreements that people negotiated themselves with a utility company, and then after the fact, the utility violated it. Then the landowner contacts me for help, and the utility says, look, we complied with the easement. They can't prove any damages, so too bad. So I would definitely, consider that. Decommissioning would be something else to consider in the easement. If at some point the pipeline is no longer used, you want it left in your land. You could consider, proposing that they require that you could consider proposing that they remove the pipeline upon abandonment. And you could even consider including language about the purpose of it. Is it supposed to be used or limited to the use for sequestration, for permanent sequestration, I should say, or could this ever be used to for transporting CO2 outside of the sequestration area for something like enhanced oil recovery? These are just ideas of things you could propose to the pipeline company in an easement agreement. Whether whether you would ever actually come to an agreement on including all those terms is a different matter, but just things to consider. And finally, with regard to the easements, I would definitely recommend working together. It's going to be much easier for a pipeline company to pick off, so to speak, landowners one by one and force, I want to use the word force in terms of, well, it'll be much easier for them to pick off landowners one by one than it would be to, force easements out of a large group. We're all looking for the same terms. There's strength in numbers, I'll put it that way. I would also suggest working with your communities, which I think is, part of the point of this webinar. Find out what, if any, local zoning requirements there are. Some counties in Illinois have no zoning ordinances at all. So this could be a good opportunity to, educate your local officials about the projects and the risks. Perhaps a county would want to consider requiring a special use permit for a CO2 pipeline. Maybe they'd want to consider imposing setback requirements from residences or other sensitive areas like schools. Setback requirements are pretty common. I mean, they're required for wind turbines. If they're required for something like a wind turbine, then perhaps they should be required for something that could, kill you in your sleep if there is a leak. And again, use this as an opportunity to educate your local first responders and health professionals. I doubt, just like the first responders in Satartia learned, that they've got much experience with CO2 releases. Will they know how to react if there is a release? Not just for the safety of themselves as well as the people in the way. If any counties or municipalities like that impose any types of moratoria or pass resolutions regarding the pipelines, that is definitely a good step, but it won't matter though if they don't let the ICC know, which is my segue into how the ICC operates. First, generally, the ICC's proceedings are what they call quasi-judicial. Basically, I was an administrative law judge with the Commerce Commission for several years, and basically, picture a trial court without the robes. We hear evidence, judges hear the evidence from both parties or from all the parties, then weigh it. And the evidence comes in the form of written testimony and exhibits. And then we have a hearing where there's cross-examination of witnesses. Then they file legal briefs that are, contain all the legal arguments where they apply the facts to the law. It's a very long process. I don't want to sugarcoat it. It can be painful. I know some folks on this call, are aware of that from firsthand experience and engaging in other matters at the ICC. But it is a process that you want to have expert representation in. Earlier I mentioned that if you get your communities involved, county governments or municipalities, if they intervene to present their position, I've seen in the past when I was a judge that you have sometimes local attorneys intervene, but and no offense to them, but they just don't know what the process is. So I would recommend that even your local attorneys for your villages and counties, find an attorney that is well versed with ICC processes. If they do want to intervene, intervening is pretty simple. But again, I would recommend that you intervene as a group. There's again strength in numbers, and as a practical matter, you'll spread the cost. Anybody who intervenes that wants to make a difference, I would recommend having experts to testify. The company will surely have its experts to offer its opinions on various issues, and anybody who has concerns about the project should have their experts as well. I indicated earlier the ICC does have experts in many fields, but that is not all encompassing. They do have some limited experience with natural gas and oil pipelines, but to my knowledge, there is no one there that has any knowledge of CO2 pipelines. And it's, as Paul indicated, they are a different creature. In just recent experience with pipeline matter at the ICC that I was engaged in, the staff had one witness who opined on the appropriateness of this pipeline project, And that one witness admitted he had no experience with the issues that were raised in the case, but still thought that project was a good idea. So if you're not gonna, if staff is not gonna have the expertise to evaluate these pipeline projects, I would sure recommend that you have it. That would involve hiring engineers to evaluate the different aspects of it and health professionals. And as I noted there, my misspelled name of Satartia, you might even consider trying to find a first responder from Satartia. They might be able to give a firsthand account, on the record in the case, as to what happened there, how it was dealt with, how scary it was when people had no idea what was going on. So again, it would be expensive, but it may very well, make a big difference. And if you don't have experts, you can pretty much be assured the outcome will be. And if you do pull together, again, be spreading your cost. Local governments would also be helpful if they wanted to be actual interveners, like indicated earlier. And don't forget the value of the media. While the ICC does time and again, pass rate increases, despite the impact on consumers and the bad press, I'm sure they don't like it. So the bad press, that is. So I would, don't underestimate the value of a, good media campaign. And, possible goals, if you do get involved with the ICC, I would encourage you to do so because it is your right to do so as citizens. And you would definitely be affected by this if it's, on your property or near your property. I did not include on this list, outright opposition to the project. I should have included that on there. I did not mean to suggest that there's no way the project could be stopped. I was just thinking in terms of conditions that can be imposed if the commission does decide to approve it. Certainly, if you see holes in their arguments that would impair their fitness and ability, or their financial model is flawed, definitely I recommend that your experts bring that up. But if the commission does decide they want to approve it, I would have as their plan B on the record conditions for any approval. And I do want to step back there to my last slide, though. If you do have government interveners, as indicated earlier, if they do want to pass resolutions, that's all well and good, but they need to actually get in the case and get it on the ICC record. Make it part of the testimony and the exhibits in the case. If it's not in the testimony and the exhibits, it's not part of the record. And the commission is bound by law to base its decision on the record. So the record, again, is just the testimony, the exhibits, the cross-examination at the hearing, the legal briefs that are filed. Somebody just pointing out, sending a letter in to the commission saying, here's a copy of our resolution. Doesn't amount to a hill of beans. I'm sorry, but this is the way it is. But again, getting back to the possible conditions, as I indicated earlier, setbacks from residences and other sensitive uses. The commission has on other pipeline projects imposed monitoring and alarm systems. Again, given the unique nature of CO2 pipelines, I would suggest that you propose conditions that would involve training first responders and health professionals. Put that obligation on the pipeline company, not on your local government. In many cases, I suspect a lot of these fire departments, probably volunteer forces. I know they are in my town. So they don't have the budget to go out and, acquire the training, and for that matter, acquire the appropriate equipment they would need, such as, oxygen tanks and masks that would allow them to venture into these areas. So surely they have some, for, entering a burning building, but I'm not sure that's gonna, be the same for all of it, for the same type of problem you're going to have with the CO2 pipeline. So it's worth looking into and to consider what type of equipment first responders might need, and then pitch that to the ICC as a possible condition on any approval of such a pipeline. So I think with that, I may have run over my time, but I will stop my screen share here and turn back over to our next person, Pam.
That would be That would be Pam. Hi, everybody. I am Pam Richard, and I too am a member of the Coalition to Stop CO2 Pipelines. I want to spend just a few minutes with you before we go into our Q&A. One thing I want to do is, first of all, thank all our presenters, and thank you, John. You were really, really thorough. And I want to pick up from one of the things that John said. And that is that Navigator is not supposed to be approaching landowners before they have filed their application. We've heard with the ICC, we've heard that's happening. And if they are doing it, they could potentially be fined $30,000 for each and every offense. So I'm putting into the chat, which we have just opened, a link to a form that we are asking landowners to fill out, if you would, right now, that is going to ask if you've been approached. And if you say to me, even though you can't say that to me directly, well, that hasn't happened to me, I'm not going to fill out the form. There's a second purpose for that form. And that is, there's a question there that asks if you are interested in engaging with others, as John has described, to share costs for legal representation. So that would be useful to us as we organize in various ways and link you to appropriate personnel. So if you could do that now, that would be great. If you're not a Google user, and I know a lot of folks are not, we'll send it out again with the promised question and answers to the answers to the questions that have been raised at tonight's webinar, and then we also will be moving along with that. We'll send the questionnaire again in a different format. That's what I'm trying to say. So,
Pam,
yes,
excuse me for interrupting, but we don't see the link yet.
you don't.
We don't see the link in the chat.
I have put it in the chat and I have made it available to everyone. I'm going to do it again.
Okay.
Do you see it now? No?
Not
No,
yet.
no. It's my fault. It's my fault. I'm sending it to John only. Let's try that again. John doesn't need it. Although John, you should fill it out. Try that. Yes?
Thank you. Yes, perfect.
All right, so thank you. And it really would be helpful to us if you could all fill it out tonight. So thank you for that, Sally. So before we begin with the Q&A, I'd just like to put into context where we are as a coalition, where we're headed. So we are in the initial phases of this work, and we've been at it for less than 2 months. And as you have heard, this webinar has provided a wealth of information that can serve as an overview of the project, its impacts, and what you need to know about the approval process. Some of that's been covered really in more detail than I expected. But I want you to know that the coalition also plans to help organize landowners, to help organize the municipal officials, county board members, township supervisors, and the emergency responders to do what we can to form the groups that John has talked about, so that we can, in fact, be prepared to intervene with the ICC. And we do have the tools at our disposal to do that. And we'll want to follow the 2011 Carbon Dioxide Sequestration Act for both process, but also for some of the things they're going to be looking at when deciding at whether or not to approve this project. So we're going to be talking to local officials about zoning and updates to codes. We're going to be talking more about impacts to farmland. We're going to talk with the emergency responders, and we're going to be doing that in formats that are Zoom formats, but two-way, not a webinar like this one. So, so watch for that. The other thing I wanted to do before going into Q&A, and some of this is coming out in the questions that I've seen so far. There are two other points of intervention. We've talked and focused tonight solely on the ICC with little reference to those other places. But what I also want to say is when Navigator does file its application with the Illinois Commerce Commission, they also have to file one with the U.S. Army Corps of Engineers. And that process, we believe, is going to trigger an environmental assessment and core permitting. Now, it's likely without intervention, and all of us here, I hope, are going to be willing to be part of doing what we can to make sure that we don't have that perfunctory review that could be done by the feds, and they could end it with a finding of no significance. It's our intent to make sure that doesn't happen, and we're going to be pushing for more comprehensive review that potentially can move into the preparation of an EIS, an environmental impact statement. So I would like to make sure that everybody knows we're not there yet, but that's another step that we'll be talking about after the Navigator has filed its application with the ICC. And similarly, there's another process, another approval process, again, touched on briefly tonight. The company will have to obtain permit approvals rather from the US EPA for its sequestration well that will store CO2, or to be able to use that CO2 that is captured for enhanced oil recovery. So you should know that we're trying to be on top of that process as well. And again, we're going to be reaching out to you to help engage and do what we can to ask the right questions and to do whatever we can to make sure that it's not an easy thing for them to get. So you'll receive a lot more information about this if you sign up with us and move forward, and we'll make sure that when we send information to you after this webinar, you know exactly how to do that, because it will be in writing. You can click a link and boom, you're signed up. So now I'd like to take the opportunity to hear from our guests. And as Joyce noted at the very beginning of the program here, we did in fact have a format ready for you tonight that puts your questions in the Q&A versus the chat. And I see them coming in the chat because I didn't close it back up again after putting that link in. We want them to use the Q&A because we want to make sure we capture every single one. And you'll find, as you see on the screen, that little square shows you where to go. But we recognize that some of you might in fact be having trouble with that. And if you are, we have a plan. So if you are having trouble and find that you can't on your device locate that Q&A button, please do call Sally. You can contact her by text or phone, and her number is listed in the screen, 618-779-5378. And if you don't get her right away, that's because she, in fact, is taking care of other people who have the same question. So again, 618-779-5378. So with that, Lan, let's bring the presenters in and we'll begin the Q&A.
Are we ready to go ahead and start with our questions? Okay, I'm going to go ahead and start with the question that was put in the chat, and then if everybody will move over to Q&A, that will be terrific. And we do have a lot of really great questions. Kathleen asks, do counties have the authority to set zoning requirements for the pipeline, such as setback from residences? Not sure who wants to take that one. John, would you like to take that one?
Yeah, it's fine. I was just technical difficulties. Anyway, yes, it depends. Largely, yes, counties have authority to impose zoning requirements, within their territory. The wrinkle here is that if they try to impose safety requirements on the pipeline, that gets into the federal preemption issue that Paul raised earlier. And talking about the Pipeline Safety Act. Setback requirements can certainly be done if they're not, attempting to regulate safety per se. As indicated, there are setback requirements commonly put in place for wind turbines. Usually it's, from what I recall, it's like the height of the tower and plus 50% or something like that. If there was some type of indication of how far the CO2 cloud could travel. I think Paul is looking into that, or at least had someone looking into that. that might be a good source to help a county guide, a setback requirement from residences and other sensitive areas. But generally, yes, I would say they do have authority to impose setback requirements. Well, I can't tell if you want to say something there or not, so, okay.
Well,
Thank you for that.
Anne, are you going to ask the next question or do you want me to?
Sure. There were two people had asked, when does the 11th month timeline start, and have they filed, and would that filing start that 11 months?
I'll take that. The 11-month deadline, 11-month timeline starts on the day they file their application with the ICC. It has not been filed yet. Last I heard, it was supposed to be filed in April, but then I also heard recently that might have been pushed back. So I don't expect it any sooner than April, but there are ways to monitor the ICC's website to see when that kind of thing is filed. It's pretty easy to do. I could tell show one of the webinar organizers how to do that. So to help people, stay abreast of when it is filed.
Thank you. Thank you for that, John. We have another question and I'm not sure, but I'm going to send it to Paul. And this is from Bridget. And she says, a lot of Illinois farmland had mineral rights sold off decades ago, meaning the current landowner doesn't have control over those assets. Does this also affect one's ability to permit pipelines on the land? In other words, does no mineral rights mean no authority to allow or deny access?
Well, I might palm this on to John since he's an Illinois attorney and I'm just a Minnesota attorney. But my guess, and John can correct me if I'm wrong, is that the pipeline isn't deep enough to affect mineral rights. So if the mineral rights are sold off, then putting a pipeline wouldn't implicate the mineral rights. Is that more or less right, John?
Oh, Paul is right, yes. And I'll note that AMA document I referred to earlier, it calls for the pipeline to be at least 5 feet deep. And that's nowhere near where you'd have to hit, where you need to be to hit coal or any other minerals.
Okay, thank you. Just a reminder for folks, if it appears that we're not answering your question live, it may be that we're trying to make use of our experts who are with us, but we will answer your question after tonight's event if we don't get to it live. We do have a question about NEPA. Apparently an Illinois Farm Bureau attorney recently said that the Navigator project doesn't qualify to comply with NEPA. It says, however, this project is supposed to cover multiple states, include multiple rivers, and would obviously require either federal permits and or federal funding, which triggers NEPA. From your understanding, does this project qualify to comply with NEPA?
So I can take a shot at that one. Probably it does qualify, but as Pam said, largely with regard to the Army Corps of Engineers, water crossing permits and wetland permits. And the Army Corps of Engineers has tried to limit the amount of environmental review. There are environmental impact statements, which is a full review, and then there are environmental assessments, which is a much more abbreviated review. And typically the pipeline companies try to just get away with an environmental assessment by having, and it's the way the Army Corps of Engineers has manipulated the environmental review process, that it can be crossing dozens and dozens of water bodies and having significant impacts, but they can get away with a very abbreviated environmental assessment. So there likely will be a NEPA review, but it may be difficult to try to get them to do a full environmental impact statement, even though I think they're justified.
Thank you, Paul. Anne?
Steve asks, are there other CO2 pipelines in Illinois?
Go ahead.
I can take a shot at that. The only other one that I'm aware of is the short pipeline that's at the ADM Dakota facility, and it goes from their ethanol production facility to a sequestration well. And I believe the length of the pipeline is a kilometer long, something like that, or a mile. So I think it's a 6-inch pipeline. It's a very short one, and it didn't really need to go through a big permitting process because most of it was on company land. So that's really it in terms of Illinois' direct experience. And I guess I would point out, one of the maps I showed that Illinois could become a superhighway for CO2 pipeline, gathered all over the Midwest and coming down through Illinois, and then connecting it down to the oil fields of Texas. So, I think it's significant that there isn't really much experience in the state with these pipelines, but yet it could become, ground zero for massive pipeline development.
Thank you, Paul. We've got,
That's the only pipeline I'm aware of. Sorry.
no, go ahead. Yeah.
That's the only project I'm aware of in Illinois.
We have 2 questions from Representative Sue Scheer, who's with us tonight, and welcome to her. I'm going to combine them into one. So she says, we know the what that a pipeline rupture can take place. Why is there not a federal or state statute that addresses the when? And at what point is the pipeline in danger, a true danger in terms of rupture, pressure, or an environmental hazard? Some minimum standard must exist. And we'll combine that, I think it's okay to do this, with why are tax credits in existence for a pipeline that could rupture? So she refers to the European example. So why are we funding this crazy scheme? Oh, who would like to take that? That sounds like a Paul to me. And then we can, everybody can have a turn.
Yeah. Well, let's talk about why they're doing it. And I think it's a political reason and justification for wanting to build pipelines. There haven't, as the oil and gas industry goes into decline, although it's hard to say what will happen now with the craziness in the oil and gas markets, there's a very large pipeline construction industry that really wants work. And, they go to Congress and they lobby to get things built and get government fundings, to keep their jobs and keep their businesses going. And that's part of the reason for this. Now, there are some folks who believe that these pipelines will help stop climate change, and they can use that as a justification for building them. But there's definitely arguments about whether that's in fact true. But in any case, so the pipelines have been supported in part because of industry wanting them, because it's a huge amount of money that they can earn, and then some folks who think this is going to help stop climate change. So that's that. And what was the question about the pipeline safety issue again?
Safety. Why is there not a federal or state statute that addresses the when and at what point of a rupture? Because we know it's we know what and that it can take place. And at what point is the pipeline a true danger in terms of rupture, pressure, or an environmental hazard? Surely some minimum standards must exist.
Well, that is sort of the question, and you'd think that the standards would exist, but you have to realize that the way the federal pipeline safety law is that the standards were originally set, and they haven't changed very much for oil pipelines since 1981, I believe, when the federal regulations for oil pipelines came out. And what those regulations do is essentially adopt by reference industry standards. So the American Petroleum Institute actually does detailed standards for pipeline construction, design, operation, and maintenance. And then these industry standards are just adopted pretty much lock, stock, and barrel by the federal government. And the federal regulators really don't do a lot more than sort of rubber stamp what the industry wants to do. And the question is, what are the standards for CO2 pipelines, and are they really adequate or not? What the companies tend to be saying is they're going to, like, for example, apply the American Petroleum Institute 5L pipeline standard, which is the steel pipe strength standard for pipelines, which was developed for oil and gas pipelines. But there's particular sets of models and particular engineering rules about that standard. But it's not clear that they've been adapted for CO2 pipelines, and that there may not simply be reliable standards for when these pipelines weaken. It's not just how strong they're built initially, but they also, the standard has to say at what point as they corrode over time, as all pipelines do, at what point do they become so weak they become dangerous. And it's not clear that the engineering models can accurately predict when a pipeline is going to become, a CO2 pipeline should be repaired or replaced or taken out of service because it's just become too damaged over time. the standards for gas and oil pipelines are quite clear that way, and it's well understood technology. This is quite different, and it's not clear the industry in the United States has really grappled with this adequately.
Yeah, I would just add that, a lot of it, again, as Paul indicated, was politics. And one thing that concerns me deeply is that the ICC simply does not have a lot of engineering experience with pipelines generally, but specifically, I'll say it again, I don't think they have any experience with CO2 pipelines. We, in a case I was involved in recently, we raised serious questions about oil pipeline and the risk of surge overpressure. And again, the staff personnel just did not have any experience with it, but thought it was a fine idea. Let's do it anyway. So, and I'm not exaggerating. Paul was there; he can verify that. I would be very concerned about what the ICC does with this. And I will, again, I'm a little jaded about Illinois government. I will note that, one of the commissioners now his prior career was, Illinois AFL-CIO president. And I'm not trying to badmouth labor unions, but, I have a hard time betting that he's going to betting against him voting no on a project that's going to, result in, a lot of union labor jobs. So, I think it's very important that, anybody who's got concerns about this, raise them on the record at the ICC. So at least if something does go south, they can't claim they didn't know or weren't warned.
Okay, thank you. Another question. I heard at a meeting last week that eminent domain didn't apply to the pore space, the underground location where they plan to discharge the CO2. Is that correct? If so, and no one approves to provide their pore space below their land where the CO2 can be discharged, can the project be stopped?
Probably an Illinois law issues. Maybe I'll say this. I am not aware of any Illinois statute that would allow the company to condemn pore space, that far underground. So if they can't get a place to put if they can't get a place to sequester the CO2, it kind of nullifies a lot of pretty much nullifies their project. To the extent to which a county could, bar, sequestering CO2 within the county, I don't know the answer to that, but it'd be worth considering.
Yeah, I'll just add that, and maybe Pam has the statute or the bill number, but there was a bill proposed this year in the state legislature to be able to condemn pore space. And the fact that they were proposing that bill indicates that there is not an existing law that does that. And just so people understand, usually what those bills say is that if a company can get 60 or 70% of the people voluntarily signed up to use their land for carbon sequestration, then the remaining balance of the people who might oppose it are subject to have their pore space condemned. And it's a pretty common kind of process in oil and gas states like Wyoming, North Dakota, and Texas.
Thanks, Paul. We had a question. So if landowners as a whole wish to object to the project, would it be wise to contact the administrative law judges directly since they make the ultimate decision? Or what is the best area or level to contact for concerns?
Having been an ALJ, I'll take that. Do not contact the ALJ directly. That would be considered an ex parte communication. That is basically a communication that occurs outside of the record of the case. They have to report that, and it cannot be used in making the decision. I recommend that all communications to the judge have to be on the record in order to be considered. I will note that there is a provision in the ICC's rules and in state law that allow the public to comment on matters before the commission through the commission's website or by calling, their consumers division. But again, because for due process reasons and under parties have to be able to cross-examine their opponents and confront their, confront witnesses against them. The comments, the public files legally cannot carry hardly any weight, if any weight at all, because there is no cross-examination. They're not sworn comments for that matter as well. So, legally these comments don't amount to anything, even though the law requires the ICC to take them. Again, I think it was more of a feel-good type bill that was passed several years ago that required the ICC to take this. Having said all that, I don't know what goes through the mind of a commissioner when they cast their vote. So, could they in their mind think, oh gosh, 500 people oppose this, so I'm going to vote no? Yeah, they could do that. We would never know what they're thinking. So I don't want to discourage someone from making the comment, but I'm just saying as an attorney, legally, they don't really count for anything.
And that's disappointing. But that's what you've said to us as we've chatted. And that's why we're going to band together and talk about groups that can intervene. So I have a question here from Jim and Terry. And I'm not sure what the exactly is being referred to here, but I think our Illinois attorney probably will. And I don't know if this section, do the 302.30 and 302.40 requirements apply to Navigator requesting permission to survey a landowner's land? And if not, are there specific requirements preceding the request for surveying?
No, those provisions only apply when the company is coming to negotiate a lease. They can reach out to you and ask to survey your land, and you can tell them no. And there are no rules though about their survey request. But I think I answered the question there, but tell me if I didn't.
I think so. I hope so. I'm going to give it a go in writing. So thank you.
Must Navigator prove a need for the pipeline in order to receive approval? No?
No. As I indicated earlier, the state law, that Carbon Transportation and Sequestration Act, it pretty much, already takes care of that for the company, because it says that, let's see here. It says that the pipeline is a public use. It is in the public interest. It's a benefit to the welfare of Illinois. It kind of sets it up as already having demonstrated the reasonableness of wanting to do it. The other provisions, though, in the statute would, if they can satisfy, reasonably satisfy those other provisions in the statute, I think they've arguably met their need burden. And again, speaking from experience, whether something is needed is up to the commission, and that's pretty subjective. They will, in one case, they may look at the evidence and say, nope, that's not needed, and then look at very similar evidence the next case and say, yep, needed. So it's subjective, and if there is sufficient evidence against it, that's your best case for proving that the company didn't meet their burden. If someone doesn't put on any evidence at all, the only evidence in the case is the company saying we want to do this, I can pretty much guarantee the outcome.
Thank you.
We had a question. Is there adequate evidence or research to document that the CO2 will stay in the ground forever and that it will not cause other negative interactions?
You want to hear a story? I was involved a few years ago in a matter in an Illinois county concerning Nicor Gas Company. And back in the 60s, they got permission to build an underground natural gas storage field in the area of Ancona and Garfield, Illinois. I believe those are in Livingston County, but I could be wrong. They got easements from all the landowners in that area to store the gas. I believe it was about 3,000 feet below the surface. And the ICC approved it and conditioned it on the gas not interfering with, the water tables, and the gas staying, well below in that 3,000 foot down area. Within a few years, the company was back to landowners saying, hey, you know what, we would like to change those easements to allow us to collect gas, say about 25 feet down. It turned out that the cap rock they were relying on to keep that gas 3,000 feet below the surface was fractured. And in their defense, no one can be sure what the geology is like that far down. It just turned out they picked a bad spot, and the domes that they were hoping to capture this gas in had cracks in them. And so the gas has just leaked to the surface. And what is frustrating about this experience is that this started back in the 60s. It's still leaking gas. These gas fields are still in use. Farm fields are being, productivity is harmed because when that gas comes up and displaces the other, stuff in the soil, the oxygen in the soil, it impedes, crop development. I have seen videos of water full of, water in ditches, and it's bubbling because there's that much gas coming up out of the ditch. And this has been brought up to the ICC, Illinois Department of Natural Resources, I believe the Illinois EPA, and no one's done a damn thing. If you Google WCIA NICOR gas field leaks, some combination like that, you'll find some recent reporting by a reporter with WCIA. Video, talking about the same stuff I'm talking about, documenting it. And to this day, there's gas leaking out of that gas field. And I say all this because no, there's no guarantee that the CO2 is going to stay that far down. They can't guarantee that. I'm not aware of anyone that can guarantee that they will, never have the subsurface gas, whether it's natural gas or CO2, never come to the surface. I don't know, Paul, if you have any thoughts on that.
Yeah, I would just add that the way the CO2 sequestration wells are either permitted by the EPA or by a state of its delegated authority to the states under the Class 6 well program. And the Class 6 well program states that once they stop pumping sequestered CO2 into it and they seal it up, then they have to monitor it for a relatively short time. And when the company finishes using the sequestration well, they basically transfer the well and the liability for any leakage from that well and that field to the state. So Illinois will take on the liability if that sequestration site fails. So it's, and again, another way that the federal law just really makes it easy for companies to take the money and then literally run.
Jessica, do you want to add to that, or we haven't really heard from you? Okay, because I know this is a question that you would probably have answered as well. Okay, so I'm looking at the time and I'm thinking there's a few questions that might be of interest, but we do want to wrap up. And I think Joyce's comment might be one that would be Joyce Harrent that we could ask and then look at the other ones in writing, and that would include Governor Pritzker taking a position on this. And I just want to say we will answer all these questions. So the question Joyce asked, which might be good to do with our experts here, she says, I am interested in knowing what a public safety review includes. Is there any jurisdiction that has this defined, or is it in the law somewhere? What defines public safety? I don't know who wants to take that.
Well, I can tell you under the Public Utilities Act that the ICC is, operates under. There's no definition of public safety, in this part of the statute. So it is what the commission deems it to be on that occasion.
And as part of that question about the pipeline safety or the generally safety, what do you think?
generally, how do you define public safety? Where do we go to figure that out? If we're going to be talking about the pipeline and how, whether or not it meets that test. Where's
Well,
that?
as I said, with the Federal Pipeline Safety Act, everybody says, oh, it means that it preempts absolutely everything related to safety. And that's just simply not true. There are multiple things that local governments can do that could be fall into the category of safety that are not, in fact, preempted by federal law. The Federal Pipeline Safety Act applies to operators of pipelines with regard to the design, construction, operation, and maintenance of a pipeline. And so, if, for example, a local government could say you can't build a hospital near an existing pipeline. Why? Because such rule would not tell the pipeline operator what to do about the design, construction, operation, or maintenance of its pipeline. It would tell a third party what they can and cannot do in terms of infringing on an existing easement. It's a really obvious example of it's a safety issue, but it's simply not regulated by the federal government. In fact, PHMSA encourages counties to take that kind of action. And then, with regard to, again, first responders and police departments, the federal government doesn't march in and tell them how to respond to these pipelines. It says that the pipeline company, again, regulating the pipeline company, has to have a safety plan. And one can look at, for example, the safety plan for the Source Valley pipeline, a CO2 pipeline up in North Dakota, and it only says what the pipeline employees will do. And it only provides equipment for the pipeline employees, not for first responders or for citizens. So again, the law there, sure, emergency response is related to safety, but what a city or town or state can't do is tell the company how to prepare its plan. That's the federal plan, but they can prepare their own plans. And then federal law says that the company is required to coordinate with such local planning. So the Pipeline Safety Act actually anticipates that, that the pipeline companies will need to work with the local authorities to work together to plan, to coordinate their separate planning processes. So, again, pipeline safety is not, doesn't cover absolutely everything. There's different things that cities and states and counties can do, and county commissioners and city officials should be circumspect about that, because there's a lot of industry propaganda out there that they can't do anything. A lot of industry propaganda, it's simply not true.
Thank you, John. I think we should wrap up our questions here and conclude this webinar. So let me go to my ending remarks, because I do have. Okay, so I do want to thank everybody for being here, for sure. And I did drop the link into the chat multiple times, and just know that we'll get that out to you again. But we want to thank our presenters and thank all of you for being with us tonight. And we did want to leave you with a few thoughts. So if you haven't picked up on this already, we are hoping that everybody will engage in this fight. Everybody, not just the coalition, not just a few on this call, but everybody. Everybody needs to do this, and we need to do it together. So that's something that I think has been a theme of this evening's meeting. And I think what Jessica said as she began her presentation is rather inspirational. She received a letter. She said, oh, this isn't good. I better go contact my neighbors. And she went door to door and began to organize, right? So first it was 1, then it was 2, then it was 5, then it was 20, then she's holding a meeting. Now she's doing webinars, by the way. So she's really into this. That might not be for you, but everybody can do something, right? Do what's best for you. Maybe it's not organizing, but maybe you can call your local officials when we get to that point. Ask them to protect you through zoning and special use permits. Maybe it's showing up to county board meetings and making your voice heard. Maybe it's writing letters to the editor, and we'll give you the tools to do that as we move forward. But whatever it is, we want you to engage and do something, because it's going to take all of us to stop this pipeline. And finally, don't sign that volunteer easement. I know, what was it John said? Seriously, do not sign an easement agreement. There'll be time for you to sign when if you decide later on that's what's right for you, but we're not there yet. And you'll hope you'll join us and all of the folks who are in Iowa, Nebraska, South Dakota, and Minnesota who are really working hard to stop this pipeline. So we're not alone here in Illinois. There's been a lot of work that's been going on before we even noticed it. At least I'll speak for me. So, and we're hearing there's going to be a myriad of pipelines crisscrossing the Midwest. So we need everybody, all of us here in Illinois, all of us in the adjacent states, and together we might have a chance at stopping this. So, and finally, Lan, I can just show my slide if that's easier for the screen. There's this is how to find us. Let's see, let me go to the next slide. We want to make sure that you stay in touch with us, right? So we have a website and we're updating that all the time. We have an email, not too hard to find, to remember, coalition, and it's at the URL of our website, co2pipelines.org. And we have a phone number and we actually answer the phone. So if you call and you get a voicemail, know you'll get a return call. So we care about staying in touch with you and we hope you'll stay connected with us. And I'll leave this up on the screen for a little bit. And with that, I want to bid you all a good night. And again, thank you for being with us. And we look forward to connecting with you in the future.